Good morning, everybody. My name is Madeleine. I'm from the Port Elizabeth branch of SMIEO, and I've been privileged enough to welcome our presenters this morning. So it's a pleasure to introduce our presenters for today's webinar. We're honored to have Madeleine Loyson, a senior part-time commissioner of the CCMA with a wealth of knowledge and a lot of practical experience. And she will be presenting today's webinar in conjunction with one of our esteemed colleagues, Komani Dhlamini. Komani's also got a lot of knowledge on this particular issue, and we are looking forward to hearing what we can learn regarding incarcerated employees. Thank you so much for your time, Madeleine and Komani. I'm going to hand over to you. Madeleine, I think your microphone is not activated.
My apologies. I always make that mistake. Good morning, everybody, and thank you very, very much for joining this webinar. Over the next hour or so, we're going to examine a difficult but increasingly relevant issue for employers and HR professionals. What to do when an employee is detained, arrested, or imprisoned. It's not a niche problem packed in a neat little box, but it touches on a number of issues: legal compliance, operational continuity, workplace fairness, and legal compliance. So our aim today is to give you a clear, practical guidance so that you can respond lawfully, consistently, and humanely when these situations arise. We just want to start with a caveat straight away that you must please note that this is not coming from a criminal law perspective. There's no criminal law focus here. We certainly aren't criminal law professionals at all. We're dealing with this from an HR perspective. In other words, when an HR practitioner is faced with an employee who advises or family who advise, this guy's been arrested, what do I do now? So that is going to be the focus for today. So let's get going. First of all, it's important to understand why the topic matters and why it's worthwhile having a webinar about this. First of all, arrests and imprisonment happen very unexpectedly. All of a sudden, you are advised that somebody's been arrested or detained. And there's very frequently confusion among practitioners about whether you are dealing with an issue of misconduct or incapacity. One's gut instinct would be to say, well, you know, this is misconduct. This person has obviously done something wrong. He's now sitting in jail. It's an issue of misconduct. But it's very, very important, and this is the primary issue that we wish to convey today. It's not an issue of misconduct. We are dealing with it as HR professionals from the perspective of it being an issue of incapacity. The employee is unable to perform in terms of the requirements of his contract because he has been arrested. Being detained prevents him from presenting himself for duty, even if he wanted to do so. So it is a form of incapacity. The employee has been prevented from tendering his services. Now, our law prior to the latest Code of Good Practice issued in September last year never specifically spoke about imprisonment, but this new Code of Good Practice, promulgated on the 4th of September 2025, specifically states that imprisonment is a form of incapacity. In other words, not only once you're locked up in prison, but being detained, being arrested, or actually being imprisoned. It's a form of incapacity, and it is not a disciplinary issue. The topic matters too because obviously there is legal risk if it's not dealt with appropriately, and the employer could be exposed to unfair dismissal claims. Dismissing or disciplining an employee simply because they've been arrested or detained can expose the employer, obviously, to a claim of procedural and substantive unfairness if the matter isn't dealt with correctly. South African case law consistently shows that employers who act without following fair process, who have a knee-jerk reaction, risk having dismissals overturned. In these situations, obviously, operational continuity, workforce planning, and issues related to what do we do now, this person hasn't turned up for work, become a major aspect. An unexpected and especially a prolonged absence, which could be days, could be weeks, months, in some cases drag on for years. It affects rostering, service delivery, team functioning, and also in many cases team morale, and we'll speak about those issues a little bit later. Employers must balance the need to maintain operations with the rights of the absent employee in mind. Additionally, there could also be pay and benefits implications. Imprisonment obviously suspends the employer's obligation to pay salary for the period of detention. No work, no pay applies. But it doesn't automatically resolve other contractual or statutory obligations and may have pension contribution fund implications, leave day implications, benefit systems implications, and various other administrative consequences that require careful handling and factoring into the equation as to whether or not it is operationally possible for you to retain this employee in your employment while he's in jail. Also, in exceptional cases, it might be a top official of the company, a senior manager, a CEO who has been arrested. And that, of course, as we know from many cases that have happened, even here in South Africa, that also affects public perception of the company, blind confidence in the company, and internal trust levels among staff. A rushed or inconsistent response can amplify reputational damage. Senior executive arrests often trigger intense media coverage that damages brand trust far beyond the individual involved. So if it is a senior person, there's also a huge amount of operational disruption, public investigations, leadership vacuums, and interventions by regulatory bodies, which can destabilize governance and business continuity. We see examples even today in our news. Human rights and fairness considerations are obviously of the utmost importance where we're talking about arrests and imprisonment of employees. Employees are entitled to due process, and they are entitled to be heard in these circumstances. Even where criminal conduct is alleged, employers must ensure procedural fairness, the presumption of innocence, and whether dismissal is, in fact, an appropriate and proportionate response. That word, proportionate and reasonable, is very, very important in this situation. Case law highlights the importance of giving employees an opportunity to be present, to be consulted, to be considered. And so we hope that from this session, you will gain a practical framework for immediate steps to take when an employee is arrested or detained, and insight into procedural safeguards to reduce unfair dismissal risk. And of course, we hope that we'll be able to give you some best practice tips. So, yeah, it's a very sensitive area where legal, operational, and ethical considerations intersect. So over the next hour, we'll move from principles, which I'm going to be dealing with quickly, to actual practice. What to do, especially within those first 24 to 48 hours. and then also how to manage longer-term detention, when and how to embark on an actual incapacity process, and how to document decisions so that they stand up to scrutiny. We encourage you to note questions as we go along, because at the end of the session, we should have some time for discussion. So let's get to the first slide. I just want to go over what we're going to be covering just quickly. We're going to look at key legal principles, the first steps to take when you hear I've been arrested, what is the situation with awaiting trial or remand or bail employees, imprisoned or convicted employees, and of course the operational considerations that have to be taken into account. We'll also cover must consider factors that you need to consider before deciding, well, okay, look, we are going to have to terminate this employee's contract. We look furthermore at when it is appropriate to convene some form of a hearing. And of course, this would be an incapacity hearing, not a disciplinary hearing. How to conduct a fair incapacity hearing and what the possible outcomes could be. Then also, if the employee is later released or acquitted and he comes back, what do you need to do in such a circumstance? And lastly, we'll also just give you a couple of case references of the major cases that have gone through our courts in this regard, and also some very interesting academic articles that you might look up on Google and read at your own leisure. So that's what we're going to cover. And let's then start off with quickly a few very basic legal principles that must inform everything that you do in this regard. First of all, and most importantly, the presumption of innocence. You know, most people, as I said earlier, when you hear that somebody, oh, you know, so-and-so has been taken into detention, her husband was killed last night and the police came and she's now in detention. Wow, hell, murder. Sure. I'm very scared in future to work with any person who's committed a murder. So most people, when they hear that somebody has been detained, the gut reaction is to immediately assume, well, you know, the police won't arrest you if you haven't done something wrong. That is entirely wrong. I'm sure you all know that. And because of that, we have in our law and in our constitution the presumption of innocence. That means that whatever is alleged, you are only guilty once you've been proven guilty in a court of law, and the court of law has made that decision. Up until the time that the court of law has made the decision, you are regarded as not guilty. You are innocent. It's only once you've been proven to be guilty that anybody can draw any inference, draw any conclusions, or act on the basis of, well, you've done so, and so therefore I'm entitled to do X, Y, Z. Now, this, of course, is a difficult thing in South Africa to get to that end point where a person is now either said to be guilty or not guilty by a court of law can take a very long time. And that has implications for the employer. This person is still innocent. You can't dismiss him until he's been found guilty for having committed that murder, for having committed that fraud, for having committed that rape. He's not yet been taken before a court of law and found guilty. So until then, he's presumed innocence, and that affects what we can do about the situation as employers. So please be mindful, no matter what your gut feel is, no matter what you have inside information about, there is a presumption of innocence up until the court has declared whether that person is guilty or not. So being arrested does not equal guilt at all. Then another fundamental legal principle is we are not dealing with discipline. It's not misconduct. We are dealing with an incapacity issue. The employee is unable to come to work because he's been detained or arrested, and therefore he is prevented by law to perform in terms of his contract. That is an incapacity issue and not a disciplinary issue. And as I said, that has now been underscored in the Code of Good Practice issued in September 2025. Yeah, please don't ever have a knee-jerk reaction when you hear that your accountant has now been arrested for fraudulently dealing with his bank account or with the receiver of revenue in his private affairs. You must investigate all the relevant factors before you decide to act in any way at all. Please remember that. Don't have a knee-jerk reaction to a charge. Fairness requires also, very fundamentally, open lines of communication. And I think that Komani, who's going to be the lead presenter this morning, will outline and emphasize that the very, very first thing that you need to do when you hear that an employee has been arrested is to establish lines of communication so that you can be informed all along the way, not only on day one to tell you this person has been arrested, but as the process goes along, that there are open lines of communication. And very often the employee is behind bars and you can't communicate with him. So that is a very important issue, and Komani will deal with it. It requires communication, open lines of communication. And then this issue of the employer, and the case law outlines this clearly, there's no doubt about it, you have an obligation to attempt to reasonably accommodate a person who has been detained, arrested, or imprisoned. Reasonably try to accommodate. And obviously that will depend on who you are. Are you a big company, small company? What is the job that this person does? What are the operational implications of keeping this person on your books, of attempting to accommodate him? And that's another topic that we are going to be looking at in quite some detail during the course of the morning. Okay, so I'm now going to hand over to Komani, who's going to be dealing with the first steps that you need to take when you hear or you receive a message that so-and-so has been arrested. Komani, over to you.
Thank you so much, Madeleine. Thank you. And thank you, everybody, for being here. As said, my name is Komani Dhlamini. So yes, I just want to pick up from, Madeleine mentioned the CCMA, and I think it's just important. I think we all know this, but I'm just going to just overstate it again. When we look at all these processes and why do I have to do all of this when somebody's been arrested, we must remember everything that we are doing is to defend ourselves against an unfair practice at the CCMA. So everything that we are discussing, everything we are talking about is all to defend ourselves at the CCMA. So always keep that in mind, that no matter how long or strenuous or the process may be, that you may feel, no, but we can do it a shorter way, always remember that if you do, you are opening yourself up to being scrutinized at the CCMA and possibly ending up with an unfair dismissal, which we obviously do not want. Okay, so I'm going to start with the first steps. When you hear I've been arrested, so your employee calls you on a Monday morning, not on a Monday morning, over the weekend, on a Saturday or on a Sunday, and he says, look, I've been arrested. I'm not going to be able to come to work on Monday. Okay. What do? Here we've got 6 points that we can all see. We're going to go through each and every one of them. Establishing a proper line of communication. Okay. If you are able to be in contact with the employee, you need to ask the employee, where are you being held? Which station are you? What is the case number? If they're not able to speak, if they're not able to speak for long, you need to find out what is their next of kin. Maybe these are information that you may have on the employment document, but ask the employee, can you give us another number, your wife or your husband or your neighbor or your cousin or whoever? Do they have an attorney? You possibly get that number. Is there a union representative? All these kind of people, these are lines of communication that as the employer, you are obliged to obtain. Again, the CCMA will look, did the employer make reasonable attempts to engage before taking any action? Okay, so it's not as simple as we couldn't get hold of him and then that was that. And we went ahead and we dismissed him. Okay, you have to show that you as an employer did everything you possibly could to try and get hold of this guy. You contacted his wife, you tried to get hold of his attorney, you tried to speak to his union representative, you tried to talk to everybody and anybody that you could, and these things must always be documented. If it's phone calls, take screenshots of those call logs. If it's on WhatsApp, take screenshots of those conversations. At the CCMA relies solely on proof and not what is what he said and what she said. So very important of starting that establishment of communication. Secondly, confirm the facts. Okay, and this happens, we're human, it does happen quite often. Do not act on rumors. Okay, as an employer, please always confirm the facts. There's a lot of workplace gossip when things like this do happen. You as an employer need to find out and confirm, is it an arrest? Okay, is it a detention? Is it remand? Or is it sentencing? Is the employee still in custody? Is bail possible? What is the charge? Okay, if you don't have the full details, you can proceed, but very cautiously. Make sure that you proceed very cautiously, because any decision that is made by you as an employer must be based on evidence and not assumptions. Again, I'm going to keep highlighting the fact that that is what the CCMA is going to look at, is how did you get to this decision? No, we heard that this happened. Oh, you heard? You need to confirm the facts. Okay, let's move on to the third point. Obtain proof of arrest, detention, and or status. Okay, so if you can't prove it, you can't rely on it later at the CCMA. Try to request documents such as proof of a detention letter. Okay, SAPS confirmation, court appearance forms, bail hearing notice, attorney confirmation letter. Okay, an employee also maybe he may not have these documents on hand immediately. So as an employee, you also have to be reasonable. Okay, have proof that you requested this information from the employee. Have proof that you gave a time frame that, okay, fine, if you don't have these documents or you can't provide them now, let's give a 14-day period. Let's give a 21-day period or whatever is a reasonable time frame. Okay, and document those attempts. As I said, CCMA is only going to ask for proof. No, we tried to ask him for his case number. Oh, really? Where? How? Okay, they're going to want to see that proof. So document all those attempts to obtain proof of the employee's arrest or detention status. Okay, next point, determine expected duration. Now, this one is quite important because this ultimately is how we come to a decision, is the duration. So the duration determines the employer's next step, because somebody being arrested for 2 days is not the same as somebody being arrested for 6 months. So you need to establish the duration or the expected duration of this kind of arrest or this kind of detention or whatever the case may be. When is the expected bail hearing date? When is the trial date or expected trial date? Is it likely to be postponed? Does it look like the employee might be released soon? Okay, why these matter is because the fairness of a dismissal often turns on how long the employer could reasonably keep this job open. Okay, and whether operational harm exists. Important to know that incapacities are not a punishment. It is all about the operational reality of the business. So definitely, if he's been locked up for 2 days, what is the operational reality of somebody being locked up for 2 days? You need to ask that question. Okay, 2 days, we can find cover for that. We can make a plan. He's being detained for 6 months. That now changes the operational reality, and it ultimately determines if this will be a dismissal or not. So the duration, find out the duration or the expected duration of the employee. Very, very, very important. Okay. Keep written records of all steps taken. I will say that throughout this entire webinar and anybody, which I'm sure we're all quite familiar with the CCMA, but we all know that your paperwork is your protection at the CCMA. CCMA cases are won on process and on proof. So always make sure you have written records, phone call attempts, WhatsApps, emails, contact with family or attorney or union representative in this case, any internal notes of meetings, steps that were taken to cover the role. If you guys had to hire a casual to replace somebody for a month or so, that must be recorded to show at the end of the day that this was a costly exercise for the company. This is what we had to do. Because the CCMA commissioner is only going to ask, before you terminated this employee's employment, what did you do before deciding? The commissioner is just going to ask, what did you guys do? And if there is no written records of every little thing that we tried to do, then most likely it will be deemed as unfair. Okay, so if the employer has no records, it becomes a he said, she said. No, I told him this, no, and then I promised this, and no, I told him I'll be out then, and this and that, and normally the employer ends up losing cases like that. So please make sure that you keep a written record of all steps taken. And the final point here, confidentiality. Okay, Madeleine did emphasize on this quite heavily. An arrest is not a conviction. And employers must understand that. Employers must try to avoid any kind of reputational harm caused by workplace gossip as well. But just going back to that, it's not a conviction. If somebody has been arrested, do not avoid implying any guilt that this person was guilty of whatever they were arrested for. In terms of confidentiality, restrict information to HR and senior management only. This is not something that should be discussed amongst other colleagues or different departments or just on the shop floor. Try to restrict information to HR and senior management only. Okay? Of course, do not announce it to staff. Unless it's absolutely necessary, your clients should not know about this kind of thing, as I said, unless it's absolutely necessary, but try to not get your clients involved. This obviously brings a huge reputational harm. And then lastly, just avoid implying any kind of guilt. This normally is very sensitive, and we must handle this kind of information very sensitively, because it can create a POPIA and defamation risk to you as an employer by implying guilt to somebody who has not been proven guilty yet. Okay. So ultimately, just to summarize that, the first steps: establish communication, confirm the facts, obtain proof where possible, determine the likely duration, document every step, and maintain strict confidentiality. If employers do these 6 things, you can reduce your CCMA risk by a lot. Okay, and we move on.
Yeah, I just want to at this stage add 1 or 2 comments. You know that getting the information, if the employee is not able to give you information, you know, like Komani said, you ask, you know, what police station are you at? And one can phone and ask for the investigating officer, who can then, you know, supply you with the docket number. Sorry, I hear somebody. Is there a question? Is somebody's mic on, or is there a question?
Yeah.
Can you all hear me?
Hi, Madeleine. Yes, we can hear you. I think Akona accidentally unmuted
Just the mic
himself.
on. All right. Okay. So, yeah, you can ask for the investigating officer at the police station. Whether he'll be there to speak to you or not, that I don't know. But try and get hold of the investigating officer, and he'll give you the docket number. You could also give you information about bail status, and of course the next court date. You could also request a copy of the bail receipt, for example, from him. And then all those officials that you do speak to, if you do get through to an investigating officer, always record the contact details. As Komani said, it's very, very important who you spoke to. If the person is already out of the police station and you are advised that he's already appeared in court and he's now been locked up or whatever, he's on remand or whatever it might be, you can always phone the court registrar at the magistrate's court to confirm whether the employee appeared, what is the next appearance date, and obtain the file number of the case or the order of the court, if there is any, if possible, so that you at least have avenues to determine where is this person, how long is he going to be there, approximately. And just as a matter of interest, our total criminal population of prisoners, as at the Department of Correctional Services report for the 24-25 financial year, was 160,000. That seems to me to be a little bit low, but nevertheless, that was the figure of the total population in prison. Now, a large proportion of those, they reckon about 60,000, are awaiting trial prisoners. In other words, they've not yet been found guilty. They're awaiting their court case, awaiting trial employees, approximately 60,000 of them. So the person may have appeared in court, a first hearing. The court may have remanded him into custody pending the court case being heard and a final determination being made. So he may very well be in a prison, but it doesn't mean to say that he is guilty. He has not yet been found guilty. He's merely awaiting trial. And they say that there are about 60,000 of them at the moment in South Africa awaiting trial prisoners. Now, and I just want to talk about these terms quickly. An awaiting trial prisoner, that term, awaiting trial, is an umbrella term for any person charged and not yet convicted. He's awaiting trial. Now, a person who's awaiting trial might be on bail. In other words, he's out, he's free. He could come to work normally like any other employee. Or he could be awaiting trial while he is detained. where he is detained, held in prison, and they talk about him being on remand. So that normally happens where the first court appearance happens after the person was arrested. The judge views him perhaps as a flight risk, or it could be a particularly serious crime that he's been detained for, and the magistrate or judge believes, no, look, I'm not going to let him out on bail. I'm going to keep him, I'm going to imprison him on remand. So he is put into a prison, he's put into a jail, normally a police holding facility or a remand facility, pending trial. So before the actual court case where the person is found guilty, after his first court appearance, he might be out on bail, in which case he can come and work normally. He only goes back when his court date, happens. Or he could be on remand, where he is in fact in jail. Now, both those categories, whether they're on remand, in custody, or on bail, they are obviously presumed innocent. And so therefore you can't assume this person is now guilty, he's been locked up. I must now convene an inquiry and dismiss him. No. You would only need to, if you wish to, convene an incapacity inquiry where the person has been detained on remand. He's unable to come to work pending his court case. Then it would obviously be important then to determine, to find out from these people, either the court registrar, the Department of Correctional Services Regional Office, the investigating officer, the prosecutor, approximately how long do you assess this is going to carry on. If they are at all in a position to tell you, well, then you've got some information upon which to decide, am I operationally able to accommodate this person on my role of employees whilst he is unable to render his services and whilst he's not yet guilty of any crime. It's in a case like that that you might decide, look, I'm going to now have to have an incapacity inquiry where we're going to have input from managers, department, everybody. What is the situation here? What are our constraints? What are the problems that we face given the fact that we've got this employee who is unable to report, versus input from a representative of that employee to come and give input in terms of the employee's view, the employee's inputs into the situation, where a decision might need to be made. Look, can we keep him on our payroll or not? But if it's an employee who is out on bail pending trial, then there would really be no need for you to convene any form of incapacity inquiry, because technically he's not guilty and he is presenting himself for work. So unless you view that which he has been charged for as a massive risk to your company, and you can justify why it would be against your interests not to have him come to work. He's not been found guilty, so you can't dismiss him for that. But you want to ban him from the workplace until it is actually determined whether he is guilty or not. Okay? If it's that type of crime, then you might need to have an incapacity inquiry, where you then say you're going to place him on suspension, precautionary suspension. We don't want to allow him onto the premises, but we're going to place you on precautionary suspension pending the finalization of your trial. Now, obviously, that is at great expense that one does that. So it's only in very exceptional circumstances where an employer would, where an employee is out on bail, is able to come back to work, but because of the nature of the crime, the employer is very, very concerned about a potential operational risk in having him back on the premises. You would have to obviously justify that. You can put him on precautionary suspension, you have to pay him, but he may very often say that that's an unfair labour practice. And you might end up at the CCMA having to justify why you can't get him back to work. So there are these considerations dependent upon the status of the employee after the initial arrest. Is he out on bail free? in which case he can either come back to work, or if he's a risk, where you have to put him on precautionary suspension with pay, or where the court has said, well, okay, he's been remanded in jail. He's been remanded in custody pending his trial. And that would normally be where he's either a flight risk, or where what he has done is a very, very serious crime, and they're not prepared to let him go out on the street, even though he has not yet been found guilty. So if he is detained on remand, then you need to try and find out how long will that be. The employee will usually not know. You need to contact attorneys, the prosecutor, the authorities to assist you to have a sort of a assessment of how long this might be. And then, of course, you need to weigh all that up against your unique operational requirements and the potential impact of the situation. Okay, Komani, back to you.
Thank you very much. Thank you, Madeleine. Okay, so this point, imprisoned or convicted employee. Okay, once again, this was something Madeleine, highlighted quite a few times, and I'm just gonna pretty much echo what she said in just defining what imprisonment and being convicted is, because there is a difference. Okay, an arrest is not proof of guilt. Okay, a conviction is now a legal finding, and employers must treat these things differently. Imprisonment or detained waiting trial, the employee is still legally presumed innocent. Convicted and possibly sentenced, okay, that is a legal certainty of wrongdoing. Now let's move into the sub-points of conviction and imprisonment, short-term and long-term incapacity. Okay, and I think this is also a big one, because ultimately this again determines whether an employee can render services, and if not, for how long, and how can he be accommodated. Okay, the issue is not about whether the employee is in trouble or not. The issue is, can he render services? Okay, so a short-term detention, this could be either a few weeks, a few days, a few weeks. An employer should consider to explore the following things. Maybe there's temporary cover that the company can accommodate. The company could possibly use unpaid leave. Okay, could postpone any formal action until that release or a bail outcome. Okay, these are all things on some kind of, when you've determined that, okay, this is going to be a short-term thing. It'll be a week, or it'll be a couple of days. It'll be over a weekend. Temporary cover can be found. Unpaid leave can be used. Postponing any kind of formal action, is also a possibility. Now, when it becomes a long-term incarceration, this is over months or over years. Okay, the employer now has more of an argument, because the job cannot be kept open indefinitely. Okay, there now becomes an operational prejudice, and an incapacity dismissal now maybe becomes fair. Okay, so basically, the longer the incarceration, the stronger the operational justification is for termination. But very important to determine the length of the possible length of the employee's incarceration or detention. Okay. Nature of offense. this one as well, I think Madeleine also touched on this. So not all offenses affect employment equally. Okay, sometimes the question is, does the offense relate to the duties and responsibilities of the role? So I'll just, okay, I see there's a question from Leslie. Leslie, do you want to ask a question? I see you've put a message in the chat box.
Hi, Komani, can you guys hear me?
Yes, can hear you.
Like I said in the chat box over there, we just kind of jump forward over there. In what you're explaining now, we're explaining it in its perfection. This is the way it should happen. In practice, it doesn't happen this way. My employee gets arrested, he gets arrested on a Thursday. I only find out Monday morning or Monday afternoon or Tuesday morning, being arrested. I've phoned him on his cell phone. I've tried to get him to no avail. I phoned his family. In many cases, they don't even know who he is. Then when he comes back to work on a Tuesday, then we only, but they don't, his creditors chasing him. That's why they don't know who he is. So we've done all of this step. But where does the procedure factor in? We've tried to communicate. We're trying to find out. We're trying to support it, but they are not being made aware of the situation. We as the employers not being made aware of the situation.
Okay. I think maybe I'll try and answer that, and if I miss anything, maybe Madeleine can fill in some gaps. But in this case, okay, so from what you're saying is you've tried everything you possibly could, and okay, the employee gets arrested, he informs you, you are aware, okay. Okay, and you've tried everything that you possibly could. You've contacted everyone. Have you tried to contact any kind of authority? Are you basically saying you don't know where he is? He's just gone. You don't know where he is.
Like I said, the first part of the questions, the first part is I'm giving, this is imperfection. This is how it would work if it should work that way. But in reality, he doesn't pitch up for work. Then you try to phone him, send him a message. Where are you? What's wrong? It doesn't happen. After 3-4 hours, you start phoning next of kin. Do you know where Peter is? Do you know where this is? Do you know what's happening? They blatantly, I don't even know Peter. 3 days later, he pitches up at work. Sorry, I've been incarcerated. I've been locked up. I've been detained. How do I prove I made a phone call? That's my next question. I've got on my cell phone. I can say, yeah, it is. But how do I prove? But I tried to call you. You didn't answer. I phoned your next of kin. You didn't answer. In front of the CCMA, he's like, but this is my mother's number. If you could phone her. But I did phone your mother. She said she doesn't know who you are.
Yeah, look, I think that's a good question because that's normally how it happens. That's normally, you know, in practical situations, that's how it happens. But I would think that, look, if you've made those calls, if you've made these calls, surely, I mean, there would be proof on your phone that you know that you'd have. You take screenshots of that. If the employer returns at this point that you did not know where the employee is, it would have to be treated as a misconduct. It would have to be treated as an absconsion at that time. And when the employee returns, then it can be dealt with, you know, as to what he told you that he was incarcerated. I don't know if Madeleine, if you want to add anything to that.
Yes. Yeah. No, you're absolutely correct. We're dealing here with two issues. Well, let's take that scenario. Your employee just doesn't turn up to work. Your disciplinary code says when somebody's been absent from work, has not notified the employer within 3 days of the reason for his absence or his whereabouts, then the employer will treat the matter as one of absconsion. So you do that, obviously. You've not received any, you don't know where he is, he's not contacted you, anything. Your disciplinary process proceeds. However, when the employee turns up on the Tuesday and he tells you, I have been incarcerated, that changes the whole ball game. You then need to investigate, was he incarcerated? Ask him, where was he incarcerated? Where was he arrested? Contact that police station to get proof. If he says that I appeared in court so-and-so, contact the registrar of that magistrate's court. So you treat any form of absence, unexplained absence, absolutely in terms of your disciplinary code. But the minute an employee alleges that he was detained, arrested, and then released, you need to investigate that. That changes the whole scenario, because in fact what he is telling you is that he was unable to render duties because he was prevented by law. They arrested him. So the first thing you need to do is to get proof. Okay, so where's your bail receipt? Where's the court order? You know, all the types of documents that you can request to determine whether the story is correct or not. We've got various formats that you could request from your employer organizations, formats that give you an idea of what the type of questions are, the types of documents are that you need to ask an employee to provide. For example, a copy of police bail receipt, court notices, detention letters, arrest reports, the fact that you can phone an investigating officer at a police station, exactly the type of questions that you must ask. But to answer your question, the minute an employee says, I've been arrested, that stops the story. Now you need to investigate, because according to law, he was incapacitated, and that's why he couldn't report for duty. It's not a form of misconduct, so you can't now just dismiss him or convene a disciplinary inquiry because he didn't advise or you couldn't contact him. He has now indicated to you, prior to you dismissing him, where he was. And so therefore, you need to check the veracity of that story. And you need to know who to consult, what questions to ask. And of course, that's where your employer organization would be extremely helpful in assisting you. What questions to ask, who to phone, who to find out. You know, if he tells you he's been arrested, he must at least be able to tell you what police station. And that would then be your starting point, the investigating officer at that police station. Obviously, provided that the employee doesn't have, that paperwork to hand to you immediately. But you need to at least you have to investigate. Komani, does that assist?
That does. Thank you so much, Madeleine. I hope that that answer is clear, Leslie.
Just one more question. I'm taking this out of a situation that has happened in my environment. I had an employee who was detained on the 24th last year, and only we came back to work 3-4 days later. So first point being great, she gave me all the documentation. She showed she was detained. She showed the bail, and everything was done. But she got released on the Monday or the Tuesday morning, and she only came to work the next day. In my sense, I then went on a disciplinary to say, but you have to inform. There was a reasonable time from the date of being detained up until the date you were released. You couldn't inform me, but you were released at 11 o'clock. You went 24 hours. You resumed duty at 11 o'clock the next day. You didn't inform me. Now I'm saying that you contravened my disciplinary code. I can't say it was out of your control. You couldn't come to work. That I understand. But the moment you were able, you could have told me, guys, I've been detained. I'll be at work tomorrow morning. Is that the correct procedure?
Well, you see, the issue here is obviously what is reasonable in the context of that specific case. You know, I mean, I can imagine if, all of a sudden now somebody walks in the door here and arrests me or detains me. Let's say there was a murder in the flat next door to me and they want to detain me and question me. I'll be in a state of shock. When I come out of there, I'm going to be extremely upset. It depends entirely on the reasons that the employee gives for not having immediately contacted you, because after all, one's employment is a priority. You know, I think if they had to walk in here now and arrest me, I'd say to my husband, listen, just quickly phone the CCMA, say I've got a problem, and off I go. But, you know, it depends on the unique circumstances of the case, whether the decision to then actually discipline the employee for not contacting you within immediately within 2, 4, 6, 10, 11, however many hours elapsed, whether it would be reasonable or not. It would depend on the circumstances of that case. There's no black or white answer to give you. It's what is reasonable. And also the seniority of that individual. If I know I am a senior commissioner at the CCMA, I've got 10 parties waiting for me, and here they come and arrest me. You know, I can't allow 20 people to sit and wait for me. It'll be on the top of my mind, I think, to immediately just tell somebody, phone the CCMA and tell them I'm not going to be able to be there. You know, so it depends on the person's position, who he is. We can't give you a blanket answer for that. At the end of the day, what is looked at is what is reasonable in those specific circumstances. So we can't give you a yes or no answer without knowing all the facts in that individual case.
Thank you, Madeleine. I think, guys, let's just watch time. We have about 30 minutes. I see, Vera, you do have a question. Maybe let's take your question and then let's move on.
Yeah, we've got a lot to cover still. Yeah.
Yeah, we still have quite a bit to do.
Yes. Thank you very much, Komani. I just want to find out if you did investigate now and you did find that this is true and he was incarcerated. Is there any consequence? What are the next steps then? What should you do if you do find that this is a legitimate excuse?
Yes, so I mean, that's essentially what we are discussing, is that now as a company, you need to embark on you know, an investigation as to, okay, how long is this incarceration going to be? Was he arrested over the weekend, over a long weekend, and he'll be released on Monday? Is this something serious that he's going to be gone for 2 months, 3 months, 4 months, 5 months? How does the business's operations, how are they going to be affected by this? Can the business cover him for 2 or 3 or 4 months? Can they find somebody to step in? Or is this, you have a logistics company and you've got one truck and he's your only driver and you don't have any other drivers to replace. He is, you know, your main operation. He's part of your main operation. You know, these questions have to be asked and determined to basically see what the incapacity process is then going to be. Is it going to be temporary? Is it going to be, you know, will we fully incapacitate him? Will we cover him for 2 weeks? And then when he comes back, we'll deal with it then. That is pretty much what happens. I don't know if Madeleine wants to add to that.
Yeah, I just want to say, look, he's been arrested. He's released on bail. He comes out. He's maybe not even missed any time at work. The arrest might have happened over the weekend. There's nothing you can do. He's not guilty of any crime. At worst, he was absent from work for a day, 2 days, 3 days with no pay, because obviously no work, no pay. He doesn't have a medical certificate. You're not obliged to pay anybody who doesn't present himself for work. So that's really the only implication. You can't discipline him, but he's not been found guilty of anything. So it's purely he's been absent for a day or two and he loses the pay for that. Where it becomes a problem, if you view that the offence he was arrested for was of such a serious nature that you cannot risk having him back on the premises. That's where a question arises. And you're going to have to justify why you're not going to have him back on the premises. You can put him on precautionary suspension, but that means you're going to have to pay him. But that's the only implication where the employee is out on bail. The only problem arises where you don't want him to come back to work because of the nature of his job, given the nature of the crime that he's now alleged to have committed. You don't want him back on the premises, even though he's not been found guilty. But normally it will not be something of that type of serious nature. So the employee's been arrested maybe for drunkenness. They release him, he's out on bail, he comes back to work, he carries on working like a normal employee. He's not been found guilty of any crime. Once he's been gone to court, he's now been sentenced. And the sentence is a short-term sentence, or it is a sentence that about an offence which has nothing to do with his job, you still face the issue of, is it justifiable to dismiss this person? And it can be justifiable for two reasons. Your operations cannot allow him to be away from work for 2 months or 3 months, or the nature of the crime that he has been sentenced for is so serious that you cannot take him back into employment. Then you can dismiss him. So even if he has been sentenced, but if it is a minor offence and the period of incarceration is not lengthy, a month, 2 months, maybe even a couple of weeks, then you're going to have to justify very in great detail why you cannot take him back into employment. And I'm just going to give you a couple of examples of minor offences that often might not justify termination. And of course, it depends on the nature of the company and the nature of the job. But let's just take, for example, a guy arrested for having been drunk and disorderly in a pub over the weekend, and he was arrested. Public intoxication or drunkenness in a public place. They're not going to put him into jail for months and months and months. He'll probably go to jail for a month if he does. Now, he's a clerk at your company. Does that impact on his job? No, it doesn't. Maybe drunkenness might have an impact if it's somebody who works on heavy machinery and he already has final written warnings for, coming to work under the influence of alcohol, and he's now really constituting a risk to the workplace. But if it's somebody who's got no such a, if it's me, I never drink. I go to a party over the weekend and I drink, which I don't normally do, and it has a negative effect on me, and I get drunk and abusive, and people chase me out of the party, they phone the police, they arrest me for disorderly behavior. It's a once-off thing. Does that justify my dismissal at the end of the day? And also, does the token week or month, whatever they sentence me for to go to jail, does that justify me being dismissed? These are all the questions that you're going to have to answer and that you're going to have to justify. So it goes around risk, your operational requirements, the job that the person does. Even if at the end of the day he's found guilty of a crime and sentenced, does that crime, the nature of that crime, justify you dismissing him? Okay?
Thank you very much, Madeleine. Thank you. I think let's get back to our slides. We were currently busy with the nature of offense, and this is pretty much what we're just talking about. So not all offenses affect employment equally. Okay, sometimes the question is, does this offense relate to the duties and responsibilities of the employee's role? So just an example, a financial manager accused of fraud. This has major workplace relevance. Okay, a driver charged with reckless driving and causes an accident and is arrested for that. That has direct relevance to his job. A security guard that's charged with misusing a firearm and is arrested for that, that has direct relevance to this guy's job. A cashier charged with theft, that has direct relevance to the employee's job. So the reason why I'm mentioning these is because these are some of the things that have to be considered when going through an incapacity process. That, okay, even if he did this, how does it affect his actual job? Okay, a warehouse worker, a general worker at a warehouse, he's arrested for a GBV incident at home. He had a couple of drinks, got into it with his wife, and he mishandled her and was arrested. Okay, does this have any relevance to his work? Not necessarily. Okay, even though it is an offense and he was arrested for, but when considering an incapacity, you also need to look at these things. Okay, this guy stole money, but he's a financial manager of the company. That is very relevant to assessing how we go about the incapacity process. So the nature of the offense is always something that is extremely relevant to making that decision. Okay, legal disqualifications. Also, what makes an employee legally unsuitable to do this job? Okay, some convictions do not just create a reputational risk, they can create legal impossibility of continued employment. Okay, what does this mean? What does this mean? If you are a chartered accountant, I'm not exactly sure of the or let me use a lawyer who works at a law firm, and he's an admitted attorney of the High Court, and he is arrested for something, and he's maybe misrepresented himself, and he loses his license to practice law. Okay, and he works at your law firm, and this happened now. Legally, he's unable to perform this job anymore because his license to practice law has been taken away now. So he's not even able to practice. If you have a bank teller who has to register with with finance bureaus and credit bureaus and all the regulation bodies within the banking world, and is convicted and somehow loses these qualifications, this person is not legally able to work at the bank anymore. So sometimes we also need to look at these things. Some industries, an employee may no longer qualify for a firearm competency, for SERA registration, licensing requirements, clearing requirements, in aviation, banking, okay, fit and proper documents. So it's not even then a disciplinary question anymore, or even before an incapacity question, it now becomes an impossibility. It's he's incapable, or it's impossible for this person to work now because they're not able to, this license has been revoked from them. He's not able to fly a plane anymore. So sometimes these things happen. These are also things that we need to look at when determining an incapacitation. Okay. Reputational considerations. Okay, I know normally employers do panic when it comes to this. And because reputation is a real business interest, it is. Okay, but it must always be evidence-based and not speculative. I've represented clients too many times where they say, no, we lost this contract because of this employee. Okay, that cannot be speculative. It has to be evidence-based. A CCMA or a commissioner is going to ask, show us proof of this. Is there an email from your client saying that we've heard about this employee who got arrested for A, B, and C, and we are no longer going to do business with you unless you let him go and don't bring him back. That forms part of your case in justifying why we incapacitated this guy, because it has a reputational risk here. There's clients who don't want to do business with us because of this employee's arrest or whatever the case may be. So employers, you need to ask, has this become public amongst your clients? Has there been any media coverage? If you're a company that relies heavily on your media look, has this been given media coverage? Are clients complaining? Is the employee in a public-facing position? Is the company's brand directly affected These are questions that have to be asked before determining, making that decision. So employers must be very careful not to dismiss purely on people who are talking. Once again, document actual. I think Caitlin, please turn off your mic. Okay, when it comes to reputational harm, this cannot be a hearsay thing that, no, we're losing clients and, people are talking and, no, document such reputational harm. Show the operational risk that, look, we've lost a 20,000 Rand a month contract or a 50,000 Rand a month contract. This is how it's affected because of this person's arrest or detention or anything like that. Show the relationship damage with clients. Keep that. That will help you at a CCMA setting to prove to the commissioner that we had to conclude on terminating this employee's work because this is the kind of reputational damage it was causing us. Okay. Impact on trust and employee, co-worker, client relationship. I think this is, also pretty much what I've discussed with reputational damage, but also including co-workers, client relationships, or employee and co-workers. So again, this also forms as something that an employer can use as part of defending themselves. Do colleagues feel unsafe around this employee? If this guy was arrested for an armed robbery and nobody knew that he's got this little side hustle with his friends where on weekends they hijack people on William Nicol or wherever the case may be, and he's arrested for something as serious as hijacking, are colleagues going to feel safe around this guy? No. Did he assault somebody almost to an inch of their lives? Do colleagues feel safe? Clients hearing this, do they want to engage with a company like yours that allows employees charged with things like this to still work there? Okay. Is the employee in a position of trust? Okay. Is there a risk of intimidation or retaliation? Will the employee's return cause conflict or instability? These are questions that have to be asked. What is the impact of what this employee's, incarceration or arrest? How does this affect, the workplace? And this is, again, all evidence-based things that it has to be their statements from employees saying that they don't feel safe working in the same environment as this guy. People don't want to work around him. It's causing an operational risk now. That must always be documented and be able to be presented at the CCMA to show that, look, we've also gone as far as looking into our workplace. We can't operate with him being there. Clients are scared, employees are scared. Okay, so when an employer asks, can we dismiss? The real question is the employee temporarily unavailable, permanently unavailable, legally disqualified, or has the trust relationship broken down? Okay, that determines whether the matter should be treated as incapacity, misconduct, or an operational risk. Okay, I don't know if there's anything you'd like to add on to that, Madeleine.
Yeah, I just want to say this question of reputation is so important. If we just look at, I think 2 days ago or so, they announced that Tongaat Hewlett, it is a 124-year-old company in South Africa, Tongaat Hewlett, has now, is going to close. And as we, I suppose, are aware, several of their former senior executives had been investigated for misstatements and fraud, and criminal charges were put against many of them, and also several regulatory investigations. And that then, and the publicity around it, eroded investor and the public trust and confidence in that company. And at the end of the day, it's closing. 124-year-old company. Very sad.
Yeah, thank you. Thank you very much, Madeleine. Let's move on to the next slide. Okay.
So yeah, the first question you have to ask yourself is, once you now hear this person has been sentenced, he's put in custody, he's detained, he's arrested, he's been sentenced. The first question is, how long will the employee be absent? And you need to weigh that up and consider, and these things are going to be different, dependent upon the size and the nature of the business. That length of absence and the impact it will have will differ from company to company, depending on the size and the nature of the business. Questions that one needs to ask is, can you redistribute the duties performed by that employee? Can a temporary replacement be arranged? Those types of questions must be considered, must be recorded that you actually considered them, and weighed up against the length of absence of the employee. And then, obviously, again, as long as an employee is incarcerated, the no work, no pay principle applies. And there was recently a query from somebody who said that they had been, this employee is a missing person. The person is missing. Nobody knows where the individual is. There is a case number. Police are obviously investigating somebody who's disappeared without trace. But this can also happen in a case of imprisonment. We know where the person is, but he's not going to be coming back to work, earning any money, making any contribution for a lengthy period. The principles are no work, no pay. And most benefit funds, most bargaining councils don't require contributions whilst obviously an employee is not earning any money. But there might be certain funds, benefit systems, insurance policies, certain things that employers may have in place, which does require contributions from the employer, even though there isn't one from the employee. And that is something you need to decide on your own. How long are you willing to pay that? It all depends, again, on the size and the nature of the business, whether you're in a position to do so. Huge, large corporations have a greater stash of money from which to support this kind of contribution on behalf of an employee. But other companies may not be able to do so. There is no legal limit. And obviously one has to look at your bargaining council agreement, the funds agreements, which may or may not stipulate under what circumstances contributions have to be paid by the employee, by the employer. And mostly, if an employee has not worked, then contributions are not required. But in many cases, they may be. If there is a situation where some sort of fund requires that you do make a contribution, even though the employee has not worked and hasn't strictly earned any income, then possibly there might be exemption mechanisms that you could utilize to ask for an exemption for this period where the person is incarcerated. And you would justify to say you don't want to terminate employment. It's not justified in these circumstances, but nevertheless, the person's not going to be here for this extended period, and we would therefore like to apply for an exemption. Bargaining councils do have exemption committees who consider these issues. So also look at whether that route might possibly be open to you. Yeah, those are basically the operational concept, is the length of absence, the nature of the job versus the size and the nature of the business and the possibility to redistribute the duties. The obligation is, at the end of the day, to reasonably accommodate an employee, reasonable accommodation. And the word is reasonable. What is genuine, possible, or impossible for your company to do in this given set of circumstances? As long as you can justify it and show that you've applied your mind to it, you've investigated all options, you've heard the employee in the situation or his representative, you've tried to get input from him in terms of, what can possibly be done here. Would he be prepared to accept another position as opposed to the one he held before he left? That type of thing. So what are these considerations? Is this absence significant? Is it a long absence? If it's a day or two, it's going to be very, very difficult to justify. If an employee's worked for you for 10, 15 years and he's now been arrested for, public drunkenness or public disturbance, or for this argument that he had for with his wife, that really doesn't have much to do with his job. You're going to have to justify that type of thing. And so long as it's within reason, your reasoning, then no one's going to argue with you. But the question is, have you tried to reasonably accommodate? Have you considered? Have you investigated? Have you communicated? Have you taken into account all the factors? And then, of course, the issue of risk. You're not expected to put your organization at risk for any one employee, but you're going to have to spell out what is that risk and how is he and what he could possibly do, the impact he could possibly have on the company and the operations. How does that create a risk for you? You've got to carefully justify and motivate those issues. Are there alternative roles available for an employee to fill? Can his duties be adapted to accommodate this issue that you're perhaps concerned about? Let's say I was a cashier and I was caught for something that would happen. Maybe cashier is not a good job. The storeman job that Komani mentioned. And perhaps the colleagues in the store don't want to work with him anymore. Can you transfer him to another branch? Can you transfer him to another department within the company where he would not be a problem? So one has to look at what is the stumbling block to taking him back. And so therefore, if that is a stumbling block, can I possibly adapt his duties? Are there alternative roles, alternative positions? Can he be transferred out somewhere else? Can he be redeployed to eliminate that stumbling block? The issue is just how well have you applied your mind? Have you really reasonably sat down and considered everything before you take a decision to sentence this guy to unemployment? Yeah, have all reasonable steps been taken? Have all reasonable possibilities of accommodating this person being explored? And is final dismissal, final termination of the contract of employment the last resort? This, of course, as I said, only becomes an issue, is only something you need to consider where, first of all, the person's been sentenced, is now going to go to jail, is not going to be able to come to work, and it's going to be a long time, something you can't accommodate. Then you have to go into this exercise, taking all these factors into account. And if you decide, well, look, I'm going to have to terminate him, then you have that incapacity hearing where you set all this out and you justify why it has become necessary to take this step. If the person has just been let out on bail, been possibly missed a day or two of work, but you still think, hang on, this is a risk now. This person has been committed for something that I cannot possibly allow him back in this company for, then obviously, again, you're going to have to justify that very, very well. And I think it's going to be very, very hard to justify a dismissal because he hasn't yet been found guilty. To just dismiss him because he's been arrested for a certain crime, it's anything but impossible, I would imagine. Unless, of course, you've got very valid, good reason, sound reason why. And that you also would not be able to afford to put him on precautionary suspension, which is always an option you have. You put somebody on precautionary suspension. And obviously that might be an option. He's now been arrested. He's now been let out on bail. You're very, very hesitant to let him back. If you know that he's going to appear in court within a week or 2 weeks, you might think to yourself, well, okay, I'm prepared to take that expense and to put him on precautionary suspension pending the court hearing. And maybe you're lucky, maybe the court throws the case out because of insufficient evidence and he can go back to work. But like many of our cases, they might just postpone, and this carries on forever and ever. Can you carry that financial burden? So, these are the types of decisions that you are going to be faced with. But bottom line, I've been arrested. Now starts an investigation. Now starts very in-depth communication with a whole host of people to determine the appropriate way forward.
Thank you, Madeleine.
Yes. Proceed, Komani.
Okay. Right. Thank you so much, Madeleine. So when to convene an incapacity hearing? Okay, so in most incarceration cases, the correct route is incapacity because, as said before, the employee is not refusing to work. The employee is incapable of working. And that's where the incapacity word comes in. The employee is incapable of doing their job. It's not that they refuse. It's not that they are committing a misconduct. They are incapable of doing their job because they are in incarceration. So when to consider this? Almost always when somebody's been arrested, the first thing to do is to consider an incapacity hearing. Okay, so when is accommodation not possible? Okay, the employer should only move towards an incapacity hearing once reasonable accommodation options have been considered and are no longer workable. And what do I mean by that? Let's just say the company has attempted and has exhausted all kinds of unpaid leave, all kinds of annual leave, all kinds of temporary redistribution of duties, all kinds of temporary replacements, bringing in somebody as an acting appointment, and none of these things have worked, and there's a continuous delay in this person's release, then the company has to look at getting into an incapacity process. When absence or risk cannot be managed, okay, an incapacity inquiry becomes necessary when the absence becomes indefinite. So that's, pretty much what we have been discussing. The duration of an arrest normally determines how we go about this process. Okay, was the employee detained with no bail date or it's unknown to you? Okay, has the employee actually been convicted and sentenced? So for 12 months or 18 months or 24 months, they are going to be locked up in prison. Has there been a sentence? Okay, does the employee hold a critical role in the business and the business cannot function without a replacement? Okay, does the employee's alleged offense create any ongoing workplace risks? Clients refuse, staff fear, there's risk with regulation boards, things like that. These are questions that have to be answered. Is when does it become necessary? When the absence becomes indefinite, how does the company go about this? And what needs to be asked when the employee's absence is indefinite? The purpose, yes, and to assess the impact on employment, not guilt. Okay, this as well, very, very, very important and has been repeated from the very beginning. An incapacity hearing is not a criminal trial. Okay, you as the employer are not there to determine whether the employee is guilty or is not guilty. Your only job as an employer is to determine whether an employment relationship can continue. And any kind of inquiry that involves this should focus on the availability to work. Were there alternatives that were explored? Is there an operational prejudice? What is the likely duration or detention or incarceration of this employee? Ultimately, whether continued employment is actually feasible. Okay, you as an employer, your only job is to assess whether there is a capacity to perform. It's not to make any kind of moral judgment or any kind of legal judgment. It is just to assess whether this employee can perform their duties or not. Okay, procedural fairness requirements. Okay, another big one. And those of us who have been to the CCMA know how important procedure is. This is one of the first things the CCMA will always look at. Even if the employee is incarcerated, the employee still has the right to a procedural fairness. So notifying the employee of the incapacity hearing in writing, okay? Allow them to respond, even if it's, via written submissions or verbal submissions, allow them to respond. Allow representation, a union, an attorney, family assistance where possible. Okay? Consider postponement. If the release is imminent, if they say, look, it can happen in 2 weeks, allow time to maybe postpone your incapacity process. Okay, allow the employee to provide proof and explain his expected timeline. Keep minutes of everything, records of proceedings, and keep outcomes in writing that, look, we discussed this with him. He says he's going to be back in 2 weeks, and we'll do that. Put that all in writing. Okay, if the employee cannot attend physically, the employer can still proceed in absence, but must prove they made genuine attempts to involve the employee. The process was not rushed. The employee was given a chance to respond. Okay, fairness at the end of the day, a fair process is not optional just because the employee is unavailable. As an employer, you have to do everything in your power to try and make sure that the process is fair. Okay, running a fair incapacity hearing. Okay, once again, the hearing must not feel like a punishment. It must feel like a structured process to decide whether the employment can realistically continue. Appointing a chairperson. This chairperson must be impartial and ideally somebody who can apply fairness and not emotion. Okay, preferably an HR specialist, an external chairperson, or a senior manager who's not necessarily involved with what happens down there with employees. Okay, avoid employees' direct supervisors to be chair people. Okay, if possible, because there could be a conflict risk there. Because at the end of the day, a chairperson must be able to justify at the CCMA why they made that decision. Okay, notify an employee's representative. Notification essential. If you don't invite them properly, your whole process becomes procedurally unfair. Send a writing to the employee, to their attorney, to union rep, next of kin. That must include the date, the time, the venue, purpose. What is the purpose? Incapacity due to incarceration. Okay, a right to submit written representations if they can't attend. Okay, even if the employee can't attend, they must be given the opportunity. Okay, representation is fair, is a fairness safeguard, especially when the employee is detained and cannot fully participate. So oftentimes you'll find that maybe the employee can only be there telephonically, and maybe somebody physically will have to be there for them. That would be a union rep, that would be a fellow employee, that could be a legal rep, that could be a written statement that was brought by a family member or an attorney. So allow assistance. That word reasonable, very important. Allow reasonable assistance for representation. Okay, explaining the purpose, very, very critical. Explaining the purpose and the process to the employee. Important to do this, and I always make sure when I have these kind of processes, I always make sure you explain what this actually is. Why I'm saying that is because a lot of times we confuse this for a disciplinary hearing. Okay, it's important to explain as the chairperson, why is this hearing being held? Okay, what is the outcome of this? Because this is not a misconduct disciplinary hearing where we're going to get final written warnings or we're going to get dismissals. The possible outcome is to determine whether this person can work or not. So you must explain that. Okay, what factors are going to be considered within this process? Okay, present the operational impact. And this is where, as an employee, you have the responsibility to put facts on the table, not emotion, but the facts on the table. Okay, show the proof of absence. Okay, if you're in a CCMA setting, show the client complaints, show the overtime costs. How much is it costing to replace this employee? Show the inability to meet deadlines. Show the inability to comply with legal requirements. This is a security guard. We're currently using some guy who does not have a SIRA certificate, and it's a legal requirement to have somebody who's got a SIRA document. And right now we're breaking the law actually by using this guy. So we need our guy in. These things have to be shown. Okay, consider the employee's response. The employee's version, it matters. Okay, even if they're incarcerated, they must be given, if they give you a time frame, or they must be able to propose any kind of solutions. That any chairperson that's sitting in on this kind of hearing should consider an expected release date, should consider a bail hearing date, any medical issues, possibility of temporary arrangements, whether absence is beyond the employee's control. They must be considered, not unreasonable requests by the employee. Of course, everything must be within reason, but they should be considered. The employee's submissions should always be considered. Okay, and then before termination, the employer must show that they explored alternatives. Okay, what do these alternatives look like? We tried to use unpaid leave. That's an alternative. We tried. We tried to use annual leave. That was an alternative. We tried to find a temporary replacement. That was an alternative. We tried to get in an acting person. That was an alternative to redistribute the duties, to postpone, because we were of the view that his release was coming soon. These kind of accommodations have to be documented and shown that, look, we explored absolutely everything that we could before we made a decision. Okay.
Yeah, so, once you've had the hearing, possible outcomes could be that you decide we're going to retain this employee. Given all the inputs that we've had from everybody, it's possible for us to accommodate him with or without adjustments to his position. You could perhaps agree on a temporary arrangement over a period of time that you are going to revisit. That would probably be an outcome in the South African situation where we really have no clear indicators of how long these cases are going to take, and with constant postponements and problems with prosecutors and people like that, that you might very well agree on a temporary arrangement subject to review in the future. You might agree that you're going to redeploy him to another branch for certain reasons. You may decide at the end of the day that, there's nothing that can be done. The incarceration is too long. The reason for incarceration is directly related to an issue that we believe is a great risk to this company, and so therefore we are going to terminate. But you're terminating on the grounds of incapacity. Obviously, like with any other dismissal, you have to give an outcome. Written reasons for the dismissal are required as per usual. And you also have to inform the employee of his right to refer such a matter to the CCMA if he is unhappy with the outcome. Now, very often you've dismissed the employees off the books, and 2 or 3 years later, he comes back and he asked whether there is any possibility of getting his job back. Well, we would advise that you reassess your operational needs. He served his time, he served his sentence. He knows the company. There may well be benefit. He may have learned a hell of a lesson through his period of incarceration. So do reassess operational needs. Do evaluate the risk afresh. And, if possible, take the man back. He's paid his penalty. He's done his time. Please consider assisting such an individual, if it's at all possible, within your organization. But just remember, if you do it for one person, you must do it for others. You have to ensure that you are consistent. You can't allow one person to be returned to the company and you deal with that person sympathetically. And if I come along and say, sorry, not interested, goodbye, you've been dismissed. Make sure that you act consistently and that you set a precedent in whatever you do. You set a precedent. And that consistency is one of the very important considerations in dealing with employees in these kinds of situations. It's important to remember, lastly, please document everything. Names, times, dates, places. Record and keep records. Keep the documents together. Also, your employer association, labor consultants, can be of absolutely great assistance here. They have set formats. They have all the wherewithal, the knowledge, the experience to advise you from the get-go. Look, contact so-and-so in this set of circumstances. Ask for so-and-so, ask for this and that. So don't hesitate. Don't wait too long to contact your employer association and get guidance when you are faced with a situation where an employee advises that they have been arrested. Very importantly, we want to just underscore for the last time, make sure that from the minute you hear the employee is arrested, that you record communication channels. Names of family members, lawyers, places, people that you can communicate with. Name of the investigating officer. Name of the police station where you were. Name of the correctional services centre. Names of people that you've communicated with. Family members that you can contact once the employee perhaps becomes incommunicado, having been arrested. They might allow them certain privileges at certain places where they are kept incarcerated, and then perhaps another DCS facility might be much more strict and not allow phone calls or receipts of messages or whatever. So just always keep your eye on open and effective, valid communication channels that you can utilize. Be consistent in whatever you do and avoid assumptions of guilt. It is a matter of incapacity and not misconduct. So there are a few case references here that you might read, some well-known cases. The latest one was the Sibanye-Rustenburg Platinum Mines matter, the issue of long-term incarceration. And again, the operations in that situation were severely affected. So, you can just type these into Google search and you'll get the case, and you can read what the courts have had to say about incarcerated employees and what the factors are that they look at, such as we have outlined this morning, their reasoning. And then there are academic references. The well-known Grogan, he writes beautifully in very simple language. Bosch and Leroux are, of course, great academics, and they also deal with imprisonment in these articles, so you can just look them up on Google. They are there. I just want to check with Dhlamini and with Komani. Am I correct to say that any attendee who would like a copy of the slideshow could just send an email to Dhlamini? Dhlamini, am I correct? If they would like a copy of this, of the slideshow? Dhlamini, are you there? Komani?
Yes, I'm here. I'm here.
Is it correct that participants can request a copy of the slideshow?
Yeah, from Dhlamini, yes.
Okay, Komani, the last word to you.
All right, no, I think thank you so much for rounding everything off. But if I can just say to everybody in here, if there was anything that you should have learned today, is that at the end of the day, when an employee is incarcerated, the biggest risk is not the arrest itself. It's how the employer responds. It's how you guys as employers respond to this thing. That is all a CCMA is ever going to look at. It's not going to ask what was the crime, what he did or what she did. They're just going to ask, how did you as an employer handle this thing? Okay, please avoid acting on panic, on rumors, on emotion. An arrest is not a conviction, and the workplace is not a court of law. Okay, the correct approach is always to respond professionally, gather facts, and follow a fair process. Okay, but yeah, overall, thank you very much. Thank you for your time. I think if there's any questions, I do see that there was one question by Estelle. If we can maybe just answer that, and then we can finish off. I'll maybe just read the question, and Madeleine, you can maybe try and assist. The question reads, what may be the best course of action if the employee has been arrested due to an alleged crime committed against the employer, i.e., he is arrested after hours while breaking into the liquor store where he works. He gets out on bail, and now his attorney advises him not to make contact or talk to the employer, as this may impact the criminal case against him, which is still sub judice. Okay, that is a question from Estelle.
Yeah, this, of course, is a very, very unusual situation. The very basis of an employment contract is that there must be trust, the trust relationship. A dismissal is justified where an employer can show that the trust relationship between the parties have broken down irretrievably. An employee, as a very basic element of his contract of employment, is to act in good faith towards the employer, always only to act in a manner that serves the best interests of that employer. And if an employee is caught by the police breaking in his own workplace, well, yeah, all right. There's now two issues. You have a situation where the employer would be entitled to immediately institute a disciplinary inquiry against the employee for conduct which is against the interest of the employer. Okay, you can get proof that there was that police arrested him attempting to break in. You now have a disciplinary inquiry, which is not whether he is guilty of the criminal offense of break and entry. That's not what you're going to be doing. You are going to be having a disciplinary inquiry into, first of all, this trust relationship. His breach of his duty, and this is a common law duty, doesn't have to be in your disciplinary code. It's a common law duty in any employee's contract of employment. It's implied. So if you don't have it written in your rule, it doesn't matter. It's an implied term of a contract, of any contract of employment. You must act in the best interest of the employer. You now have proof as the employer, this employee tried to black and you've got the report from the police, the arrest documents, report, and maybe security guards that came in and see. You convene a disciplinary inquiry against that employee and you can dismiss him. Even though he's not been in court, he's not been found guilty of breaking an entry, the fact that he was attempting to do anything like that is in breach of his contract of employment. He was not acting in good faith against the employer. Komani, does that cover it?
Yes, 100%. Yes, 100%. I think Madeleine is spot on. So in an event like this, the company must go ahead with a misconduct because he broke into the workplace. That has nothing to do with the criminal part of things. That is for SAPS to determine. You are now embarking on an internal process because he broke into the workplace, and he would then go for a disciplinary hearing. And then on the second part of it, if the company is also pursuing criminal action against him, then you would also follow the channels of that separately. But those are two separate ways of dealing with them. And in this case, you know, I would advise the employer to deal with both, to the internal disciplinary hearing as well as pursuing any kind of action with legal action against the employee. So that's how I would add to that. There's another question here from Andre. What if an employee only responds that he is unable to respond due to his incarceration, but wants to participate, but as a result of his incarceration cannot and request the process to be postponed until he's able to do so? This is his responsibility every time the employer asks his response in writing or by outside help. Okay.
All right, now, you know, certainly be reasonable with the postponement. What is the reason why he can't respond? I don't think in any prison they would deny an employee the opportunity of sitting down, writing on a piece of paper what his input is going to be. If that is the case, if the employee says, no, they won't allow me to write a document or whatever, there is a body which is part of correctional services set up. It's the judicial, what is it called? The judicial, I have the name, the JICS. I just know about JICS. But it's part of correctional services. All right, you can just contact their head office is in I think it's in Randfontein or somewhere up country. But the JICS, if you just Google that, you will see it's Judicial Inquiry Services. They are an oversight body, part of correctional services, which assists employees where there are allegations of unfair conduct towards them, you know, people who are incarcerated, that assists them if they are being treated unfairly. And it certainly would be unfair if a certain correctional services institution or prison says to an employee, no, sorry, we're not going to allow you to just write on a piece of paper, you know, inputs that you would like to give to this inquiry that's going to happen at your employer. If that is what the employee is saying, I would contact the JICS, and say to them, look, this is what's happening. These people won't allow this Mr. So-and-so to just draft a document to give input into a very important meeting that is going to determine his employment prospects. And they will then assist. But yeah, I mean, I think most prisons would allow an employee to write up a document and to send it through to the employer. Komani, what's your view?
No, I 100% agree. I agree with everything you said. I don't think I've got anything to add on to that. I think that is the appropriate channel for a situation that Andre just gave. So thank you.
Yeah, I mean, if the employee says that, you can say, listen, okay, look, I'm prepared to postpone for a week. I hear you that you're not prepared because of what, but there is a body such as a JICS within correctional services. They assist employees where there's any complaint of unfairness. Contact them, or ask the family to contact them, or you can try and contact them on behalf of the employee and make a plea that they just allow him to draft a document for the employer. Yeah, okay. Thank you.
All right, thank you very much, everybody. I think we've gone over time, and I just want to leave with everything that we have discussed. Is of course to educate you, but it's always wise to always contact your labor, your labor partner, your labor practitioner. We are here. We're always available. Please reach out to us if you have any kind of issues around what we've discussed today. Please feel free to email us, to call us. We will gladly assist you. Okay. Thank you, everybody, and enjoy the rest of your day. Hope to see you at the next one.
Thank you so much, Madeleine and Komani. It was very insightful. We appreciate your time.
Thank you. Thank you, Komani. Thank you so much.
Thank you, guys. Thanks, guys. Bye-bye.
Bye-bye, everyone.